So thank you so much, Lisa, for being here. And yes, this is kind of a continuation from where we left on the seminar. There were some questions from the people, and I just wanted to get to them. So the first one is everybody knows that having a will is important, but can you expand on the benefits for tax purposes?
Sure. Thanks, Adriana, for having me. I appreciate you doing that. So with respect to the benefits from a tax perspective, you could look at them from different areas of tax. So the first reason you want to look at doing your estate plan is because it gives you the ability to see whether or not you're going to actually have to apply for a certificate of appointment. And that means, in layman's terms, probate. So there's probate tax. And probate tax basically is captured for any of your assets that are here and anywhere in the world except for real property. So if I have stocks and bonds in different countries outside of Canada and I don't have a will and I die without a will, all of my assets get calculated. Whatever that gross amount is at the date of death, that's what I'm going to pay probate tax on. And probate tax is 1.5% of my estate, not including the first 50,000 that you'll be given as a break. So you get the first 15,000. So on the first million, you pay 14,500. And then on every subsequent million, you're paying 15,000 in probate fees. So this is important because you can avoid paying this is if possibly you can have a primary will, which will capture your personal assets, which will be subject to probate tax. And then you can have secondary and tertiary and any amount of wills that can cover assets here, like corporate assets, where you can transfer shares that won't be subject to probate fees, the 1.5%. You can also have wills outside of the country that are either drafted in another country, which I always recommend, or if you don't, I have clients that just don't want to be bothered with doing wills outside of the country. And so we'll do a will that will capture just those assets that are outside of the country so that we can avoid having those assets being used to calculate the probate fees here. So that's one area of tax. Then you also have income tax and you have capital gains tax.
Mhm.
By looking at your estate plan from a tax perspective, you may not be able to save taxes just by drafting your will, but by actually trying to take, a constructive look at what your assets are doing, what your estate is doing, what your corporation that you own shares in are doing, then that's will start to, initiate the conversation. Oh, hey, is this a point in time where we want to talk to our accountant? Do we want to look at perhaps doing an estate freeze? Are we eligible for a lifetime capital gains exemption? What type of capital gains tax are we going to be subject to? Is there a way to mitigate this tax? Should we put together a family trust so we could take advantage of the lifetime capital gains exemption for a multiple amount of people? So with looking at your estate plan, I think it opens the doors to look at tax in a broader scope, not something that you may be able to save by putting together a will, but something that you could work on with your accountant so that you're looking towards the future. So you're doing some estate tax planning with your accountant. And also when someone dies, you also can do post-mortem tax planning. So you can do what's called a pipeline agreement, which I'm not going to get into. You could do another type of rollover, which is like a 164(6) that's in the Income Tax Act. So it's all of those things that I think benefit people when they start to look at their estate plan instead of just keeping your head down, working. And then at the end of the day, when you die, you're hit with all of these taxes that could have been avoided, deferred. There are so many things that are available, whether or not you should have had life insurance to mitigate your tax risk. I don't know, right? But all of those things can be looked at. So I think that covers the first question.
Yes, absolutely. And actually, you just mentioned within the body of that about the possibility of having more than one will. I don't think everybody knows about it. It was new to me too, that there is many reasons why it's important to have a different type of it. So can you explain something about a little bit about two wills or why is the
Sure.
difference?
Of course. So generally, if we're just talking about two wills, and as I mentioned before with question one, is you can have two or three or four, or any amount of wills that you want. But one will that you have will just take into consideration personal assets. So for example, your principal residence that will need to be sold, let's say upon your death, unless that's going to transfer to a beneficiary, right? Because a principal residence, remember, that's one of the bonuses that we have, that it's not taxed, right?
Mhm.
That's a tax-free. So, but if you have a principal residence and it is going to be transferred, in order to transfer that, in order to transfer real property, which is like actual property, you actually have to have a certificate of appointment. You have to probate. And if you have to probate, it means you have to pay probate tax. So with that personal will, that will probably encompass your principal residence. It will also probably have things like your investments, your non-registered investments, your RSPs, your TFSAs. And when you have those assets, with RSPs and TFSAs, you can name beneficiaries, but that's essentially what's going to be in your primary will. In your secondary will, if you own shares of a corporation, or you have other things like jewelry or art or any expensive, some people have wine collections, things of that nature, you can put all of those things in a secondary will, which will not require getting a certificate of appointment. And by not getting that certificate of appointment and applying to the courts, you save on the probate tax. Now, with that, there's also a caveat that if I'm the executor and I'm saving on the probate tax, I also may want to get a certificate of appointment because that covers me, because you can't go behind the certificate of appointment if I'm going to be giving out money or liquidating things, right? So you still want to be careful as an executor, but as a testator, someone who's making those wills, those are your options to have different wills, more than one.
Excellent. So I think no one knew about that. So that's good to know. Now, you mentioned that it's important to review your will regularly, but can you elaborate how often that needs to be done and why is the case? Like additional cost, actually, if there is any cost with this review.
Sure. So I always let clients know that if there's any major changes, so if there's a change in marital status, if there's a death, if there's a change in income or net worth, or any major life change, that's always a good time to review your wills. So if you get separated or divorced, it's always a good time, because when you get separated or divorced, you're not going to want your spouse to receive all of your assets. And generally speaking, for most people, everything goes from husband to wife, or your spouse or your partner, whoever that may be, and then let's say to children. And in the event that there's a breakdown in a relationship, obviously you want to make those changes. So that's always an indication. I also say to my clients that it serves you well to at least look at your will every 3 years. With me and my clients, I always let my clients know that I'm always happy to take their calls. I do not charge them when they call me to just ask me or tell me what's going on, just to have a little, update so that everybody's kept in the loop, so I know what's going on with their estate. And so if it's just, a very short conversation, there's been no changes, there are changes, ask some pertinent questions. There's generally no fee for something short. But if you get into, half an hour, then it is at my hourly rate. And I can't speak to whether or not other lawyers charge. I don't know how they work, but that's how I work.
Okay, fair enough. It's good to know. And the last question that I have for you is we always talk about wills online. Now it's popular to do everything online. You don't need to go to see anyone. You just do it by yourself. But you mentioned that that is not the case always with wills in particular. And I wanted to know if it has to do with the jurisdiction, or is it apply only here, or in other provinces is different. So just tell us a little bit about that.
So with respect to do-it-yourself wills, I don't recommend it. There's just too many things that can go wrong, because the person that's doing it online probably has no legal background. Even just the simplest of mistakes could cause an intestacy. Now, the courts have changed the law. I believe, I don't even remember the year at the top of my head. I think it was I want to say 2022 or 2024, but don't quote me. But now we have rules of substantial compliance. And what that means is that you draft a will, and the courts may be open to hearing, and to looking at the will to try to establish what was the intention of the testator. So for example, I do a do-it-yourself will online. I sign in the witness section instead of the testator section. The courts might look at this and say, yes, we think that the testator made a mistake. It's, we're going to say that it complies with the law. We're going to let this through. We're going to say that they have a will. But taking these chances are really a terrible way to go, because what's going to be cheaper? Going to a lawyer and getting your will done the first time properly for, however much money, which is going to be nominal, than if you have to go to court and have a court tell you whether or not they think that a will is valid. I assure you that's going to be a much more expensive process and timely process.
Mhm.
And if you do it yourself will and you get it wrong, well, then you're suffering an intestacy. And so everything that you've tried to achieve on this DIY will is now going to be tossed out. So I definitely do not recommend them. I've also seen some DIY wills. I think that the way that they're drafted is confusing. I think sometimes the way that they, their precedents are not good. I would not rely on them, and I definitely would not recommend them. With respect to whether or not they're just in Ontario or other jurisdictions, I have no idea. I only practice in Ontario. I do cross-border with clients who have assets, but that really has nothing to do with DIY wills and whether or not they're available. I don't know. And I have no idea whether it applies everywhere. I personally, just from my professional point of view, I would not recommend a DIY will.
Okay, so that is helpful. Thank you so much for your time. I guess this will satisfy some of the curiosity that people express on the meeting. And once again, thank you. Hopefully, we get to have you as a guest in the future.
I would love to be a guest. Thanks, Adriana. Thanks for taking the time. You're just such a nice, person, and I really do believe you genuinely care about your clients, and I'm always happy to answer questions. And if you have anything you want to ask me, by all means, reach out anytime.
Absolutely, we'll do that. Thank you. Have a good day.
Thanks, Adriana. Bye.